This podcast contains sensitive material which includes murder and violence. It will not be suitable for all listeners. For a list of confidential support, please see our show notes for more details or visit our website. Listeners' discretion is advised. The Swan River runs through the metropolitan area of Perth, Western Australia, extending for 72 kilometres, or about 45 miles. On the north bank, bounded by the Indian Ocean and the Fremantle railway line, lies the affluent suburb of Mosman Park. From 1926 to 1972, Mosman Park was well known as a productive industrial centre, with large factories lining the river and highway. In 1994, Flora Metallica, a popular Mosman Park jewellery shop, was just a short walk from the junction of Glyde Street and the Stirling Highway. Owned by 45-year-old Pamela Lawrence, the shop specialised in gold-plated jewellery pieces and gifts, each handcrafted in a workshop at the rear of the premises. The shop was easily accessible from the nearby railway station, across the road from which stood a taxi rank. On Monday, the 23rd of May 1994, severe storms, torrential rain, and winds so strong that trees were uprooted tore through the city of Perth. During the day, Lawrence braved the weather and left her jewellery store for the shops to undertake her regular errands. She returned to the workshop later that afternoon. Jacqueline Barsden was a colleague of Pamela Lawrence. She worked at the front of the jewellery store. When her shift finished at 3 p.m, Jacqueline stepped out into the cold and slippery streets and turned the shop sign around to let the public know the store was closed for the evening. On occasions like this, when she left earlier than Lawrence, Jacqueline Barsden would lock the front door. After that, Lawrence could be contacted through an intercom. At this point, the downpour had become so heavy that power lines were down and traffic was banked up, drivers unable to see more than a couple of metres ahead. Areas of Perth were now off the grid, completely blacked out, which meant most shop owners had left work for the day because there was no light to continue operations. Lawrence, however, stayed back and took the opportunity to catch up on some work. At 5:20 p.m, Pamela Lawrence phoned 2 customers before, completely unexpectedly, she was struck on the head with a heavy blunt object. Her near lifeless body was dragged to the back of the store, where she lay in a pool of her own blood, while her attacker fled into the gusts of the storm, leaving her for dead. Police were quick to begin a public appeal for information following the brutal attack. Phone callers to the police nominated a large number of people who might have been of interest to the investigation. Lloyd Harvey Pearce was one of the callers. He informed police that, at about 6 p.m. on 23 May 1994, he had seen a Caucasian male run from the alley behind the jewellery store and across the road towards the railway station, where he appeared to have an argument with a taxi driver before running off and subsequently boarding a train for Fremantle. Pierce detailed a description of the man, but officers failed to follow up his account, a failure which would later prove to be a crucial error. Out on the street in the banked-up traffic, Jacqueline Barsden's 13-year-old daughter Catherine sat in the passenger seat of her grandmother's car at a set of traffic lights, across the road from Lawrence's jewellery store, Flora Metallica. As she glanced over at the shop where her mum worked, she reported seeing a man standing down, bobbing out of sight as if he had seen her glance at him. He was wearing a gypsy-type scarf, she said, with an orangey-type border around the edge. Confused, she kept looking into the shop to see if he would pop back up, but the traffic lights changed from red to green, depriving her of any opportunity to see him again. When Catherine arrived home, she told her mother what she had seen. Miss Barsden told Catherine to sketch the man she saw and to make some notes just in case. It seemed particularly odd that a man in the shop would make himself scarce once spotted. If it had been Pamela Lawrence's husband, Barsden thought, he wouldn't duck out of sight like that. Back at the shop, Lawrence's husband Peter arrived at 6:30 p.m. with their daughter Katie. He noticed that he couldn't hear his wife working and thought that was a little odd. The shop didn't appear to have been closed properly for the night, as a light was on inside, and a mat and pot plant still outside in the rain. It was unlike Lawrence for the shop to be in disarray, but he thought if she had been locked in, that could account for the unusual state of things. As he made his way towards the back of the shop, he heard a noise and looked around. Then he stumbled over his wife's bloodied body near the rear workshop. At this stage, Pamela Lawrence was alive, but lay in a thick pool of her own blood. Peter's face paled as he realised his wife had been bludgeoned in a violent attack. In a panic, he rushed his daughter Katie away, telling her breathlessly that Pamela had been attacked. Peter placed a cloth over her wounds and put her in the recovery position before calling an ambulance and police, just 7 minutes after his arrival. Paramedics rushed to bring Lawrence out of the shop and into the ambulance. When Katie Lawrence arrived home, she made a distraught phone call to the hospital to find out what was happening. She was told that the paramedics had stopped CPR in the ambulance because there was nothing more they could do to keep her mother alive. Blood pattern analysis at the premises indicated that Pamela had first been struck near the front of the shop, then dragged to the rear, before being struck again and left to bleed. She suffered extensive head wounds and died on the way to hospital. An autopsy revealed that she had at least 12 cuts to the scalp. Police struggled to establish a motive, as no jewellery was stolen and her handbag wasn't taken. A small amount of money had been removed from her purse, but certainly not enough to kill for. A significant manhunt then ensued. 136 people were included on the list of suspects. Catherine's description of the man in the shop window was central to this listing. 31-year-old Andrew Mallard was nominated to investigating police as a potential person of interest. After leaving school, he had spent about 8 months in the army before being medically discharged. After that, he had a number of short-term jobs, moved interstate, then overseas and back again, and was generally unsettled. In August 1993, Mallard's general practitioner described him to his treating psychologist as somebody with a long history of psychological challenges. In the period leading up to 23 May 1994, Mallard had been leading a marginal life. He had no fixed place of abode, but would be able to persuade people to let him stay with them in return for cannabis. He was receiving social security payments but was also operating as a con man and petty thief, and substantially living on his wits. He claimed he could speak a number of languages, often declared an interest in Celtic design, spiritualism and related matters, and at other times claimed to be a Highlander, a Viking or a warrior. He had a number of minor convictions, the majority of which were for traffic matters, apart from 2 for stealing and 1 for escaping from custody. On the evening of Sunday, 22 May, the day before the murder, Mallard committed a burglary in Mossman Park, directly behind the jewellery store. He stole a bicycle and a leather jacket and impersonated a police officer. The burglary was reported to police, and the following day Mallard was arrested, charged with the burglary, granted bail and released from the East Perth lockup at about 3:47 p.m. Less than a few hours later, Pamela Lawrence was murdered. During this period of the investigation, Mallard was twice remanded to the closed ward at Greylands Hospital for assessment under the Mental Health Act of 1962. The principal forensic psychiatrist, Dr. Jeremy O'Day, diagnosed him as suffering from a hypomanic phase of a bipolar mood disorder, and considered that while his cognition appeared intact, his overall social judgment was impaired. While he was in Greylands Hospital, Detective Sergeant Caporn and Detective Emmett interviewed Mallard on 4 separate occasions. He gave the detectives a number of alibis which were unsupported by the witnesses he nominated. The evidence elicited during those interviews was only circumstantial, and Mallard consistently denied being responsible for the death of Pamela Lawrence. 2 weeks after the murder, a sample of Mallard's blood was taken, at which time he remarked, "This will clear me." Unfortunately for the police, forensic examination of the shop premises and Mallard's clothing failed to uncover any forensic link between him and the scene. 8 days later, Mallard was in court to answer his charges of larceny and impersonating a police officer. He was then subsequently released on bail. Mallard was then invited by Detectives Caporn and Emmett to return to police headquarters at Curtin House for another interview. Reluctantly, Mallard agreed. He had already been questioned about his whereabouts and was exhausted. At police headquarters, Mallard was asked over 15 times what occurred the night that Lawrence was attacked. Once again, Mallard gave a variety of explanations, but ultimately, under sustained questioning, he gave in. He admitted that he went into the shop that night to case it for a burglary, but he soon retracted his words before again denying any involvement in murdering Lawrence. Not long afterwards, this emotionally unstable man started crying. It was then that Mallard began speaking in the third person, saying that the person who murdered Pamela was very scared and did not want to get caught. Then Mallard began to speculate how Lawrence may have been killed and drew a picture of a wrench. He said this evil person hit Lawrence with the wrench, saw a girl in a car looking at him, ran out the back and threw the wrench into the ocean at North Fremantle. When asked if this evil person was him, Mallard said it was not. He became hysterical at the accusations and his treatment by the police. In a fit of panic and confusion, he bit Detective Sergeant Caporn on the leg. That resulted in another assault charge. Upon his release on bail, Mallard was put under police surveillance, and an undercover cop using the codename Gary, befriended him in an attempt to elicit either evidence or a confession. But no evidence of Mallard's guilt was discovered, and no confession was made. In connection with the charge of larceny and impersonation of a police officer, Mallard had been remanded on bail to reappear in court on Wednesday, 15 June 1994. But he failed to appear, and a warrant was issued for his arrest. 2 days later, on Friday, 17 June, Mallard was arrested at 10:30 a.m. and taken to the Major Crime Squad office at police headquarters. There he was interviewed by Detective Sergeant Brandham and Detective Carter for hours on end, concluding at 2 p.m. During the interview, Mallard again made a number of inconsistent and contradictory statements and admissions, before saying that he did not go into the shed or murder Lawrence and had made it all up. Mallard said he had been able to provide the details from what he had seen in the media and from what he had otherwise heard had happened. When he was asked again how he knew all of the details, he said, "Maybe I'm psychic. All the things I told you is what I imagine the killer would have done. I got inside the culprit's head. I got inside the killer's head." When asked if he was prepared to be interviewed on video, he said, "I want to be video recorded so that I can be cleared." Due to the state of his mental health, partway through the interview, Mallard again lapsed into the third person, purporting to describe what he imagined the actual killer would have done. Mallard said, "It's my version, my conjecture of the scene of the crime." Following the interview, Mallard was readmitted to Greylands Hospital for further psychiatric assessment. For the purposes of the application for him to be readmitted, Detective Sergeant Caporn wrote a letter to the police prosecutor, setting out grounds of the application. The application may have been justified had it not included incorrect and misleading information, as it did. Mallard was then formally charged with the willful murder of Pamela Lawrence. Detective Sergeant Sherville prepared a summary of facts which was forwarded to the Director of Public Prosecutions. The summary was a 30-page assessment of the evidence, as well as the strengths and weaknesses of the prosecution case. The letter referred to Mallard's transient lifestyle, the psychiatric assessment, his behaviour, and the undercover operation, but made no reference to material alterations to the statements of witnesses. It made specific reference to a list describing 12 things which only the killer would know, but made no reference to the numerous errors Mallard made in the details, such as the layout of the shop. The preliminary hearing was held in November 1994, 6 months after the brutal murder. The trial commenced on 5 November 1995 and ran for 10 days. The Crown Prosecutor, Kenneth Bates, conducted the case on the basis that the murder weapon was a wrench, as Mallard had drawn. He relied on the confessions obtained from Mallard on 10 and 17 June 1994. The murder weapon was not found, but a Dr. Cook performed tests using a variety of weapons, including a wrench, by striking a pig's head, to try to establish from the shape of the wounds whether any of the items tested left marks the same as those left on Pamela Lawrence's head. However, at the trial, when he gave evidence, he was not asked by the prosecutor whether any of the tests he had conducted included using a wrench. That was despite the prosecutor relying on the sketch of a wrench made by Mallard as indicating a wrench was the murder weapon. Catherine Barsden's evidence in relation to when she stopped at the traffic lights was described as significant evidence of opportunity, that a man in the shop window ought to have committed the crime. The case was presented that the man Miss Barsden saw in the shop was Mallard. Despite her original statements of the person wearing a gypsy-type scarf, Detective Sergeant Sherville had edited her statement, so the final version, which was read in court, made no reference to the sketches she had drawn or to the scarf. Catherine's statement referred to a hat she was told Mallard frequently wore back to front. Further, there were no references made to 23 and 24 May and the identical picture drawn at that time from her description. Further, there was no mention that on 3 June 1994, Catherine failed to identify Mallard from a group of photos of males who looked a little similar to each other. Prosecution also presented evidence that at the time of his arrest, Mallard was staying with a woman named Michelle Engelhardt. In her original statement, made on 29 May 1994, Ms. Engelhardt said that when she returned to her flat at about 3 p.m. on 23 May, she noticed Mallard's cap was hanging on the hook behind the door, and that when he returned home before 7 p.m, he was not wearing any kind of headwear. However, in the final statement presented at the trial, all reference to the cap being on the hook was omitted, and she said that by then she was not sure whether he was wearing his cap when he arrived home. Detective Sergeant Capone and Sherville were the two detectives who interviewed these witnesses, who had their original statements changed so markedly. Concluding the prosecution case, the jury heard that Mallard gave a number of alibis to police. They also heard that he spoke to them in the third person, stating what he thought the killer would have done. The defence argued that the initial investigation and throughout the trial, Mallard talked of how he was fed information by police to repeat back to them, which the police then treated as a confession. On 21 December 1995, 33-year-old Andrew Mallard was convicted of the willful murder of Pamela Lawrence and was sentenced to strict security life imprisonment, which meant he would be required to serve a minimum period of at least 20 years. Mallard appealed the conviction twice unsuccessfully in the Supreme Court and in the High Court of Australia. After serving several years of his sentence, he petitioned for clemency. The Attorney-General for Western Australia referred the petition to the Court of Criminal Appeal, which ultimately dismissed it. The referral to that court raises questions as to the way in which the Court of Criminal Appeal should proceed in determining a reference of such a petition, and the evidence to which it may have regard in doing so. Throughout Mallard's appeal requests, Lawrence's family were told by police and prosecutors that they were quite comfortable that they were doing everything they could to make sure Mallard stayed in jail. Notwithstanding his life sentence and conviction, Mallard maintained his innocence. The submission was made by Mallard's lawyer, Mark Ritter, that there had been a miscarriage of justice because detectives chose not to use video recording equipment when interviewing him. In an application for special leave to appeal to the High Court, Mr. Ritter said that what had been presented to the jury as confessional evidence from the interview had been just theory and conjecture by Mallard as to what the real killer might have done. He submitted that the failure to use video recording facilities placed an accused person in a position of vulnerability if evidence was fabricated by detectives. In a twist of fate, Mallard's family approached Australian journalist Colleen Egan, who investigated the case with assistance from then Western Australia Shadow Attorney General John Quigley. Mr. Quigley's career history included representing police officers for the Western Australia Police Union, which provided him with an insight into police procedural failings in the case. Through political pressure, he was able to gain access to the prosecution files. When he read the transcript of the trial, he found crucial evidence that there was something very wrong. Quigley and Egan then, with a team of lawyers who were acting pro bono, that is, without any fee, worked to have Mallard's conviction quashed by the High Court. Mr. Quigley prepared a clemency petition, which he delivered to the Attorney General on 23 June 2002. The clemency appeal to the Court of Criminal Appeal was dismissed. However, an appeal to the High Court was successful. The verdict was set aside and a new trial ordered. The Director of Public Prosecutions, or DPP, then had to determine whether it would proceed with a new trial. The defence team worked hard. They presented alibi evidence and a pattern of manipulation of evidence by the prosecution. Among this were files that had been hidden from the court and the defence at the original trial. Evidence that the prosecution hid was that the statements made to secure a conviction regarding the wrench were incorrect. The truth was that Dr. Cook had examined the wrench that Mallard drew and concluded that, after the tests on the pig's head, the wrench drawn by Mallard could not have been used to cause Lawrence's injuries. Mallard's team also found that the original statements taken by the police did not correspond with the second and third statements which had been presented in court. In a dramatic turn on 15 November 2005, the High Court declared that a miscarriage of justice had occurred. The DPP determined they would not proceed with the new trial, and Mallard was released from prison. In 2006, the High Court overturned Mallard's sentence after a bloody handprint left at the scene was presented. The handprint turned out to be a positive match for one Simon Rochford, a convicted felon already incarcerated for the July 1995 murder of his girlfriend, Brigitta Davis. 7 weeks after the murder of Lawrence, Rochford became an inmate at Albany Regional Prison, where he began his sentence for the willful murder of his girlfriend. On 11 May 2006, Rochford was interviewed at the Albany prison by Detective Sergeant Saunders of the Special Crime Squad. Rochford denied having murdered Pamela Lawrence, but was unable to explain why his palm print had been found at the scene. A week later, Rochford was named as the suspect for Lawrence's murder. However, the next day he was found dead in his cell as a result of self-inflicted wounds. Rochford had killed himself within hours of learning he had been publicly named as the suspect in Lawrence's death. A cold case review of the Lawrence murder was opened. It revealed that a weapon recovered at the 1995 Davis murder scene had on it blue paint that matched paint found in Rochford's backpack and in Lawrence's wounds. While the murders were similar, the weapon recovered in 1995 was never presented to clear Mallard's name. The stick and weight used by Rochford were found in 2013 during an audit of police exhibits. The Corruption and Crime Commission demanded to see the weapon in 2007, but the commissioners were told it could not be located. In 2008, A Corruption and Crime Commission report made misconduct findings against 2 officers who worked on the case. By that time, they were both assistant commissioners, Mal Shervill, David Capron. One of the findings was that they had caused witnesses to alter their statements. Those involved in police misconduct resigned from the Western Australian Police Force, which meant they could avoid the police disciplinary process. According to Chermack and Chapman in their article Predicting Crime Story Salience, a Replication, crimes and criminal justice issues are some of the most frequently covered topics in the media. They have successfully gained large public audiences as they entail powerful emotional impacts of events on ordinary people. As discussed in our first episode, the Innocence Project, founded by Barry Scheck and Peter Neufeld, is a non-profit organisation with university affiliation. It has identified DNA science as the primary tool in freeing innocent people who remain incarcerated and to bring substantive reform to the system responsible for their unjust imprisonment. Documentaries like Australian Story, a weekly half-hour series broadcast on the ABC, Australia's public television network, provide an opportunity for the wrongfully convicted to publicly present the issues central to their case. In a 2-part documentary by Australian Story titled The Wronged Man, Mr. Mallard said, "I was wrongfully imprisoned. There's a stigma that goes with that, and still goes with that. I still get abuse from members of the public. People don't know the full story. They think I'm some sort of psycho, some sort of mentally ill patient. I had done nothing wrong. I was innocent, and I protested my innocence from the word go. For near 11 and a half, nearly 12 years, I was protesting my innocence consistently, continually, because it was the truth." ABC Australia also spoke with journalist Colleen Egan, who investigated the case and who reached a similar conclusion. It was just a cruel twist of fate that had put him on a collision course with this inquiry. And it was just a matter of fact that there were police who were willing to act dishonestly, she said, adding, "There was a prosecutor willing to run a case that wasn't quite right. And there were 3 judges who refused to believe it when evidence was put in front of them. And they saw what the High Court saw." Katie Kingdon, Pamela Lawrence's daughter, spoke about her mother's death for the first time in ABC's Australian Story, saying, "I have enormous regrets at how long it took me to realise that Andrew was innocent. I really want people to know that my family believe Andrew's innocent 100%, and we have nothing but regret for what he's been put through." In May 2009, Mallard received a settlement of $3.25 million. The West Australian Premier at the time, Colin Barnett, said the government would support Mr. Mallard's efforts should he decide to take further civil action against anyone who was responsible for his wrongful conviction. The Sydney Morning Herald reported that Mallard was extremely disappointed with the figure. According to the paper, Attorney General Christian Porter characterised the payment as a gift to Mallard, based on precedents on what a true ex gratia payment should be, and was not meant to compensate for lost wages. Mallard told Australian Story that living in Perth had become untenable, as members of the public still treated him as if he were a murderer. In 2019, Andrew Mallard was in Los Angeles, where his fiancée lived. On 18 April, as he was walking along West Sunset Boulevard in Hollywood around 1:30 a.m, He was struck by a silver car that stopped briefly before speeding off without rendering any assistance. A bystander attempted CPR, but Mallard died at the scene. The Los Angeles Police Department posted a $35,000 reward for information about Mr. Mallard's death. It was later found that 20-year-old Los Angeles basketball player Christopher Smith fatally struck him in a final unfortunate event. Smith faced a 4-year prison term, but under his plea deal he served only 1 month behind bars, performed 300 hours of community service and paid restitution to Andrew Mallard's family. Mallard's mother was 92 years old when her son died in this cruel twist of fate. His family told prosecutors that Mallard would not have wanted Smith to be sent to prison, but would want him to face the consequences of his crime. Andrew knew only too well, as do we, the trauma, both emotional and mental, that imprisonment brings. Attorney General John Quigley, who had assisted Mr. Mallard with his appeal at the time, said the US legal system was beyond his comprehension. Quigley told the Western Australian program The West Live, "I can't understand the American justice system. It's a very foggy system. Knowing that Andrew was the man that he was, and one of the most gentle souls I met, I can't imagine he would have wanted retribution, having experienced what he has experienced. I suspect it's the end of the case." Before we discuss anything further, please note, you should seek legal advice before navigating any appeals. The crime series aims to make a significant contribution to improving the competence and quality of the legal system, and to contribute to listeners' awareness and education, so you are not swayed by public opinion, but challenged to acknowledge the lack of legal processes readily available to remedy or compensate wrongful convictions. Here at Crime Series, we aim to build a community of listeners who are aware of the psychological impact of those who experience miscarriages of justice, and what avenues may be available to you. So, what happens if you find yourself convicted in Australia of a crime you did not commit? Well, after a guilty verdict is handed down, there are several ways you may be able to challenge the decision, bearing in mind that each state and territory is different. The first thing you must do is realise there will be strict time limits. Second, you must consider whether there is a possibility of new evidence being obtained, remembering that you have limited time to complete this difficult task. Once you have been found guilty, you will have to accept that because a guilty verdict has been handed down, innocence, the presumption that you are innocent, has gone. This makes it much harder to prove your innocence, and you'll be left to defend yourself against a prosecution case for a crime you did not commit and in which you were not involved. One option that might be available to you is to appeal against the conviction on any ground involving a question of law. If you have an argument that the law has been applied wrongly in your case, that qualifies as a right to appeal. However, if your appeal is on any other grounds, like a question of fact, you need to first seek permission from the court to be allowed to appeal against the verdict of guilty. The process of appealing begins by you completing a document called a Notice of Appeal and lodging it with the court within a strict time period. You may be able to appeal against your detention through a civil proceeding known as habeas corpus ad judiciendum. This is where you set out your claim and then a court inquires about the legitimacy of your custody. If the court is satisfied that your imprisonment is unlawful, you would be released from prison. Unfortunately, while habeas corpus may be an option, this avenue has had limited success, mostly involving cases where detainees in immigration facilities in Australia and Nauru have been unlawfully imprisoned. So, if the court can find a legal reason to detain you, the avenue will be unsuccessful. As discussed in our introduction episode, outside the general avenues of appeal, there are innocence organisations, which are projects supported by lawyers, academics and law students. They are facilitated by the University of Technology in Sydney, New South Wales, Griffith University in Queensland, the Royal Melbourne Institute of Technology through its Bridge of Hope Innocence Initiative in Victoria, and the Innocence Project of Western Australia. You must bear in mind, however, that this avenue of assistance would only be available to you if there is DNA evidence available to support your innocence claim. While rarely used in Australian jurisdictions, statutory provisions exist for an application known as a petition referral power. That process is that a petition is submitted to the Attorney General, who refers the matter to the court to be heard as an appeal. This avenue assumes that you have exhausted all other legal avenues. Unfortunately, there are issues due to the lack of transparency, timeframes and structure. More notably, there is potential for decisions to be influenced by politics and political motives. Another avenue of appeal is known as the Royal Prerogative of Mercy. This is a lengthy process conducted in accordance with Section 61 of the Commonwealth of Australia Constitution Act 1900, where the Governor-General has the power to grant a conditional or unconditional pardon or a decrease in penalty to those who have been imprisoned for various offences for breaches of Commonwealth law. In each state of Australia, State Governor has the same power in relation to state crimes. However, this avenue does not formally exonerate the person or remove the conviction, but it does remove the penalty imposed, like a prison sentence. So if you were granted a pardon under this avenue of appeal, you would still be deemed to be guilty. A case example of this is where Lindy Chamberlain, who was convicted of murder, pursued her appeal to have her conviction overturned after being granted a pardon. Finally, government inquiries have been used to investigate and correct a number of wrongful conviction cases in Australia. Several different forms of inquiry have been used, such as royal commissions and commissions of inquiry, both of which have been used to investigate wrongful convictions. In our fourth episode, we will discuss how this avenue was used to investigate a wrongful conviction pre-exoneration. As discussed in our introductory episode, the Criminal Cases Review Commission model overcomes many of the obstacles to correction of wrongful convictions. It has the powers and resources to carry out the investigative work required to uncover a wrongful conviction. But it's not that easy. How would a Criminal Cases Review Commission work in Australia, with smaller criminal justice systems and with different rules operating in the various different jurisdictions?